Matter before the court this morning is the case entitled City of Rutland versus Camberly Johnson and Majorie Johnson. Case number 23 AP 387. Appellants are self-represented and appearing via phone. Representing the appellee, City of Rutland, is Bariah Smith. Present with Attorney Smith is David Rue.
Okay, thank you very much and good morning. Mr. Johnston, can you hear me? Okay, good. And we can hear you. You understand you have 5 minutes and we'll try to give you an alert when you're short on time. So please go ahead, please.
Thanks. May it please the court. This is a rather hectic situation since I didn't think I was going to get in. So luckily that happened. I'm basically of the position that initially what I'm going to ask for is, after 2 minutes, reserving my time. Because in reality, I think what I have the benefit of this case is that federal bankruptcy courts under Cooper have indicated that the use of the statute of limitations is the more precise one, and the more direct one is the one that counts. And therefore, the other side came up with 501 as a mechanism where they thought they had 15 years in order to contest the loss of property. But the bankruptcy court handled that with the Cooper decision by saying, no, it's the more precise one. So that if that indeed happens, then it says that the PLAs and the other contracts are not subject to attachment. And what I'd like to add is that they have abandoned a number of claims, which they acknowledge in their brief that they are not dealing with. One was attorney's fees wasn't awarded, and so as well as a waste argument and conflict. So it was under their second amended case that they never pursued past that. And I tried to get those thrown out, and nothing happened. But it will happen now, because if the statute of limitation applies, the plaintiff's case goes away and we get to pursue our counterclaim. So that's what I'm basically looking for, is their justification as to why the statute of limitations doesn't apply. And I believe that meets our one criteria where they said I was incompetent and didn't use those precise words, that I was incomprehensible, or that I was not able to fulfill my obligations by the briefing method or whatever. So I think the court, it understands that the pro se litigants do have special needs, and therefore it would be inappropriate to put a sanction on there, because I've made a concerted effort, and it's a very simple case. I wanted to deal with the Titanic, the whole shebang, but in reality, I think we're satisfied. I'll reserve the rest of my time then.
3 minutes.
Oh, you've got 3 minutes left, sir. All right.
Yeah, I want to see what the city has, because I don't think they have a valid case. Thank you.
Okay, we'll turn to now. There are two lawyers. Are you splitting your time between the two?
No, Your Honor.
Okay. You please introduce yourself, identify your client, and then go ahead.
Mr. Chief Justice, and may it please the court, my name is Bariah Smith of SP&F Attorneys, and we represent the City of Rutland.
Thank you.
The City of Rutland has been battling the chaos and confusion wrought by appellants for the better part of the last decade, perpetuated by a frivolous legal theory that perpetual lease agreements can artificially make real property valueless and allow for the avoidance of paying property taxes. The court now has the opportunity to end that chaos. The lower court found that the perpetual lease agreements at issue were void for lacking the language of conveyance, along with, for some of them, for the grantor not having an interest to convey, and finally for being flatly absurd. To quote Judge Shafritz,
Counsel, we don't need the hyperbole. Just argue the law, would you please?
Certainly, Your Honor. The lower court found that I'm just quoting, the lower court found these perpetual lease agreements to be absurd, that she said, quote, no legitimate non-tax economic substance can be found in the PLAs, and their terms reveal no actual purpose other than to upset the city's grand list and its ordinary taxing authority as it relates to these properties. Now, to address Mr. Camberley's assertion that the statute of limitations prevent the city from attacking the PLAs, the city time and time again has said that, well, Mr. Johnston continually cites to 27 VSA 348B, which provides a 3-year statute of limitations to challenge a conveyance of property for specific defects that are listed within that statute. The city is not challenging the PLAs on the basis of any of those specific defects. The lower court found that these leases were void for lacking language of conveyance, and for the grantor, purported grantor, not having an interest to convey, and for just being an attempt to get around the property tax, get around paying property taxes. Other than what the appellant has just said here, I'm not sure what exactly he's arguing, and the city really is not on notice of any issue that is properly before the court or have been properly briefed. As we've all seen, when our institutions do not enforce the rules and norms, rules lose their legitimacy and norms become punchlines, all while chaos creeps and takes every inch it's given. We think that the appellant has not followed the rules in prosecuting this case, and the court should and can dismiss this appeal for lack of prosecution in compliance with this court's rules. And otherwise, we ask this court to affirm the lower court's decision and judgment. I otherwise rest on our briefs, and thank you for the time. Thank you, Your Honor.
Okay, thank you very much. How much time does the appellant have, please?
Appellant has 2 minutes and 41 seconds remaining.
Are you still there, Mr. Johnston?
Yes.
All right, please go ahead.
Thank you. I've had to deal with the city of Rutland on many issues, and we've been successful in a number of them. The issue that I think is important here is that it's Kimball versus Kimball, I believe, that was cited in our brief on page 1 or 2 that indicated that they simply remanded the case in that instance back to the court because they were trying to make an attack that had already been finalized. So the city doesn't have the ability, nor have they indicated how they came up with 501, because the conveyance requirement is that they can't challenge it if there isn't consideration. And that would be one of the elements of non-consideration, is if indeed they were kicked out for that basis. In their reply brief, they didn't do anything with the lower court's ruling, in terms of the lower court was doing it based upon equity and other elements, and did not do it based upon the statute of limitations that they now cite, so that there is no basis by which they would say that it didn't indicate. And I also indicated that there was, all I have to do, because we're at the stage of summary judgment as opposed to a final trial, so we haven't gotten to the appropriate parts yet, because our counterclaim, they didn't mention it at all, unless it went so quick that I didn't hear it, that all I have to do is demonstrate that there are material issues of fact available. And one of them is if I make the claim that I have a 99-year lease that I believe was recorded in the city records that indicates that I have a license to use, which they did not put in their brief, they did not attack, and therefore this is a contestable issue as to whether it's sufficient by they have notice, because they're the ones that control the product and have it in their records, so that they have taken advantage of pro se litigants by letting them hang themselves by having too much.
Sir, sir, you have 1 minute. Yeah.
Gotcha. Thank you.
No, so you have 1 minute. Yeah, go ahead.
Okay. Every time I talk, it sounds like they say don't talk. So basically, that as long as there's material fact in there, and there was a number of instances of where they contested the validity. I gave them a copy of the lease agreement, which clearly does have conveyance language in there, even if you don't. They don't cite any section, and they indicate that they're not relying on the other elements. They said there was no acknowledgement, and that's what Mello said. And he was, in that particular case, I wasn't even a party. I attempted to intervene, and they didn't let me. So the final issue here, I think, is that issues can be at any time when we indicate that they don't have the statute, they don't have the power of justification of scope, that they can be eliminated. So I think that for the purposes here, before you move on to the counterplan, it should be very easy. And the Cooper language that I made reference to in the federal court, I can provide a copy of that. But they should have provided that to start with, because it was evident in all end. Thank you for your consideration.
Yep, your time has expired. Please call a conclusion of the hearing.
Concludes today's